Hello, my name is Dr. Jackalyn Rainosek, and I'm with DTP-Leadership Group. And I have the privilege of having Richard Wilson, my very dear friend, who's an outstanding lawyer. Many of you know about him, so I'm not going to say a lot about him because you already know who he is. So I enjoy these monthly things with him because we give you a chance to look at cases, fully understand what's going on. So Hot Topic Bold Talk is a way that you can learn about the legal system once a month, and you can also learn about many other things that are going on in our country. So I want to start today. We have two major cases. So Richard, would you do me a favor and just name those cases, and then I would like to go in and give some information about Comey. But would you at least
Sure.
tell them what we're going to be looking at?
Yes. First off, and perhaps primarily, we will see where the day takes us, is US v. Comey, which are the criminal charges that were filed against former FBI Director James Comey in the Eastern District of Virginia. The second case is Lulac v. Abbott, which is yet another redistricting case, which was recently decided, and a preliminary or temporary injunction was issued in that case here in Texas. It just seems to me that redistricting is the old friend you and I can't quite escape.
Well, I think it's true, and I keep reading others, Indiana legislatures unfortunately had all kinds of threats about bombs and everything else. So many of the legislatures in Indiana have now voted to change their and redistrict because of all the threats they've received. So I think it's a sad day when a president of the United States uses threats to legislatures to get them to do something. So I'll mention that, but it's going to be coming up. So you and I'll have another discussion about redistricting, whether we like it or not. I want to talk about Comey because for me, Richard, one of the things that I really, last night I started thinking about, I watched Meet the Press, I read a bunch of articles on it, and I thought, what is the reason that Trump is so angry with Comey? So I finally looked it all up, and let me tell you what, there are loads of reasons they have, but I picked a few of them just to try to give you listeners a chance to really see what the basis of all this is. The first thing is the Russian investigation. Comey publicly confirmed on March 2017 that the FBI was investigating the possible tie between Trump's campaign and Russian interference in the 2016 election. This infuriated Trump, who repeatedly did what he does today. It's a hoax and it's a witch hunt. If he doesn't want to deal with something, he calls them that. Another reason that he's so mad at Comey is loyalty demands are from Trump, and if you don't, you get fired. So, according to Comey, Trump requested his personal loyalty during a private dinner in January 2017. And Comey was not willing to grant full loyalty because he believed the FBI director should be independent of political influence. Now, to me, that makes a lot of sense. Trump fired Comey in May of 2017, citing his handling of the Hillary Clinton email investigation, but later admitting on his social media that the Russia thing that he did was the reason he was so angry. And he fired him. Another thing has happened between him is public memos. After his firing, Comey arranged for a friend to leak memos he had written documenting his private conversations with Trump to the media. One memo detailed Trump's request for Comey to let go of the investigation into former National Security Advisor Michael Flynn. These links led to the appointment of Robert Mueller to take over the Russian investigation, which dominated much of Trump's presidency. That's another reason that dominated. Another one is the deep state allegations and perceived enemies. Trump views Comey as a leading member of the deep state. The deep state, based on Trump, is it's an entrenched bureaucracy working against him. Trump has public call for the persecution or prosecution, excuse me, it's also persecution as far as I'm concerned, prosecution of Comey and others perceived enemies, viewing the former FBI director's actions as an attempt to undermine his presidency. Now, there are many more. This is the last one I'm going to give you, though. Personal insults and book. Comey has been an outspoken critic of Trump since his firing. He's written a critical memoir titled A Higher Loyalty. From some of my friends, he's talking about higher loyalty being a support of the law and Constitution rather than bowing down to Trump. And Comey has made frequent media appearances, which has kept the feud going. Now, there's a lot more. But I think it's good to have that history because when Richard gets in and starts explaining this case, I think then you can better understand the reason that a lot of people are saying there's not a lot to this case. But anyway, Richard, I think it's really, first of all, there's one thing that's described in the case, which is called privileged information. So would you please describe that? And then would you apply it to what's going on in the Comey case?
Yes, and first let me start in particular with the US v. Comey matter. What you and I are discussing are two orders that were entered in the case. The first was an order entered by Magistrate Judge William Fitzpatrick on November 17th of 2025. The second matter, which we'll get to later on in this discussion, is an order that was entered by a district court judge on November 24th of 2025. Now, with the November 17th order, you asked about privilege, and under the federal rules of evidence, Rule 502, there's something called the attorney-client privilege. The idea behind the privilege is to allow the court system to work, whether it's a criminal case or a civil case. The rule of evidence applies to both. You want clients to be able to provide full disclosure to their lawyers. And in order to encourage full disclosure, you protect everything that a client says to their lawyer with the privilege, meaning other people cannot find out what discussions a client has had with the lawyer. There are some small exceptions, like when you use the lawyer to actually plan a crime that has not yet occurred, things of that nature where public good are seen to outweigh the importance of the privilege. But that's the whole idea with the attorney-client privilege, is really to allow better functioning of the legal system and to allow a lawyer to represent their client better. And for instance, an example you can have is turning to Comey and with testimony in front of Congress, a lot of discussions with attorneys might focus on, okay, here's what happened. If I'm asked this question, how can I answer it to avoid these issues that might be embarrassing to me or embarrassing to others while providing all of the information that is sought from the question. So turning away from that and getting to the November 17th opinion from Magistrate Fitzpatrick, there was an interesting thing that happened with the Comey investigation in the Eastern District of Virginia, leading to his indictment. In 2019 and 2020, during President Trump's first term, the FBI undertook an investigation into the disclosure of privileged information in a 2017 New York Times article. The target of that investigation was a lawyer by the name of Daniel Richman. who had, as I recall, served as an attorney within the FBI or the Department of Justice. He was in 2019 and 2020 a professor at Columbia Law School, but also acted as private counsel to people. And one of the people that had hired Daniel Richman to act as their attorney was James Comey. So in 2019 and 2020, the FBI presents probable cause to get a judge to issue a search warrant for Daniel Richman's iPhone and iPad to review his messages and see if he may have been the source of the leak of privileged information, as I understand that earlier investigation. When the FBI got that information, it included privileged communications, not just between former Director Comey and Daniel Richman, but privileged communications between other clients of Mr. Richman and himself as their lawyer. Now, in 2025, when President Trump has demands and ultimately the Eastern District of Virginia, the U.S. Attorney's Office, begins investigating Comey. The way a search warrant works is I go to a judge and I have to show probable cause to get the judge to issue a warrant so that I can go into somebody's house to look for a particular piece of evidence or get their phone records to look for a particular piece of evidence. Now, in 2025, with James Comey, the FBI and the U.S. Attorney's Office did not go and seek a new warrant focusing on James Comey as the subject of the investigation and focusing on whether or not there is probable cause to look at the communications with Mr. Richman to see if it might reveal information about Comey's testimony to Congress and whether or not that testimony was false, which is what was being investigated. So no probable cause was ever presented to get a judge to sign off on the warrant. What the FBI did was they simply went and took the evidence from the Richmond investigation 5 years earlier and then used that information to investigate a new target, that being James Comey. And included in those communications were privileged information between Mr. Comey as the client and Daniel Richman as the lawyer.
Well, if that material is being used in this case, then then no wonder there's been some decisions that we'll talk about in a minute, because it seems like to me they had no right to use that information at all.
Legally, you are correct. That's why I may have gotten your listeners bogged down, but that's why I talked about probable cause and warrants. The whole idea is if I've got something important to one investigation and I can convince a judge to let me have the evidence, well, it doesn't mean that that evidence can then be used or that I have probable cause to use it for an investigation of someone else. I
Right.
have to meet the same burden of proof if I'm looking to charge another person with a different crime. And in Comey's case, that did not happen. Legally, you don't get to just go and pick evidence out of other cases you've prosecuted, especially when you've gotten that private information by virtue of a warrant that was appropriate in that case, but that a judge might not deem to be appropriate in the new case.
Right. And I think you're really right on. I think that's one of the problems of this case. But the other problem I see is all of a sudden Trump decides one of the U.S. attorneys resigns. So then we have Trump wanting to pick someone. He then names the person he wants the attorney general to pick, which happens to be Halligan. Now, Halligan has a background with Trump because she was his personal attorney through a lot of his difficult situations. And number two, she has no trial experience to any extent that would be needed in the Comey case. Now, I'd like for you to go in and talk about the appointment of her and then what all happened with it, because it really created a problem for the defendants, because I think the defendants are the United States, right?
The defendants would be James Comey. The
Oh, good.
prosecution would be the United States.
Correct me. Thank you very much. I know your light is going out, so it's going to come back and you'll join us again. Um, anyway, what I want to say is, all right, the defendant is Comey.
Yes.
The all right, let's talk about what was extremely inappropriate about this appointment, and then what did it lead to in the entire case. And I'm going to give you plenty of time to talk about it.
Okay. Um, let's go back to what normally happens when a president takes office is under the Constitution, there are certain positions within government. It's called the Appointments Clause, where these individuals are appointed to their positions by the president with the advice and consent of the Senate. So legally, what that means is the president will pick a person and say, I want this person to have this job. Let's say Marco Rubio. I want him to be Secretary of State. Well, the advice and consent of the Senate means the Senate then has to confirm that appointment. With a lot of the lower level positions, the president can just pick someone. But with U.S. attorneys for the different districts of the federal court system, those appointments still have to be approved by the Senate. What happens is while you're waiting for an appointment to be made, temporary appointments can take place and can be made by the Attorney General. So what happened in January of 2025 is Trump took office, and as a matter of course, the then sitting U.S. Attorney for the Eastern District of Virginia tendered their resignation. They resigned from the position because they had been appointed by a prior president, leaving the position free for the new administration to appoint someone else. With the Eastern District of Virginia, what happened was a gentleman by the name of Eric Siebert was appointed temporarily to that position by Attorney General Pam Bondi. And he was appointed under a federal statute that allows the Attorney General to make a temporary appointment of up to 120 days. Siebert holds that position, and I believe in May of this year, when his 120 days was about to expire, what the district court judges in the Eastern District of Virginia did was they then got together and voted to allow Siebert to remain in that position beyond 120 days. Why did the district court judges have to do this? Well, the way the statute works is if the president hasn't appointed someone who's been confirmed by the Senate, the Attorney General can appoint someone, and that appointment only lasts for 120 days. After 120 days, the district court judges for that particular
Right.
district where the U.S. attorney works have to make the appointment. So what happened was they made the appointment of Siebert continuing beyond 120 days. As I understand it, there was pressure being applied from Washington to indict James Comey and Letitia James in the Eastern District of Virginia. The understanding is from multiple press reports that Siebert, who is a former police officer and who since graduating from law school and clerking for a federal court judge has served as a career prosecutor. He had spent 15 years as a prosecutor in the Eastern District of Virginia. It's understood that Siebert advised people that there was not a valid basis for bringing the charges. What then happened is President Trump, I say tweeted because I don't want to call his post a truth. I mean, they may be true, they may be false, but he posted that Siebert needed to go. So Siebert tendered his resignation. Rather than waiting to be fired, he went ahead and resigned from the position, presumably understanding that he was no longer wanted. At that point, Attorney General Pam Bondi, with based upon a recommendation by President Trump, appointed Lindsey Halligan as the U.S. Attorney for the Eastern District of Virginia. As you touched upon, Halligan's legal career, despite what people would say, just because I'm a lawyer doesn't mean that I'm a skilled criminal prosecutor or that I am qualified to be the U.S. Attorney for the Southern District of Texas. I've spent my 30 years engaged in civil trial work, and while I am a trial lawyer, it doesn't involve criminal cases where the rules can be a bit different. The burden of proof is a lot different.
Right. Mm-hmm.
Halligan, as I understand it, was an insurance coverage lawyer down in Florida, not a federal prosecutor. She gets appointed to the position, and there are two things that appear to have happened. I say appear because these are conclusions I'm drawing based on circumstantial evidence.
Right.
One is it doesn't appear that she really understood what she was doing or what she was supposed to be doing.
Right.
Going back to the November 17th order that we're talking about, one of the things that's really interesting in that order is the indictment that was ultimately presented against James Comey only had 2 charges. The reason this is unusual is that the charges that were presented to the grand jury and the charges on which there was evidence presented to the grand jury, there were 3 of them, not 2. What appears to have happened is the grand jury voted yes on charges 2 and 3, which both, as I understand it, involved misrepresentations or false statements to Congress, but voted no on the first charge. I don't know what Lindsey Halligan's motivations were. And here's the thing. She could have proceeded with that indictment and brought the charges against James Comey on 2 and 3, but not 1. Whatever the motivations were, her office then prepared a new indictment which only contained the 2 charges on which the grand jury had voted yes. Those charges, it appears, based upon Judge Fitzpatrick's explanation of the circumstances, it appears she simply went to the grand jury foreperson and got that person to sign off on this new indictment with only 2 charges without representing the evidence to the grand jury. Now, the 2 charges in the second indictment, as it's explained in the order, appear to have been charges 2 and 3 from the first indictment. So the argument would be, well, if evidence was presented on those charges the first time around, that ought to suffice for the second indictment. But procedurally, legally, that's not the way it works. If
Right.
I'm going to bring charges, I've got to present evidence on the indictment the grand jury issues. I don't get to go back after the fact and ask the foreperson to sign a different indictment, because then I could conceivably present a new charge that was never presented to the grand jury and voted on, and have the foreperson sign off on something that was never even presented to the grand jury. I present charges for wire fraud, and then suddenly the indictment has bank robbery on it. So while some might view it as a technicality and a simple procedural rule, the procedural rule has an effect across the board. And what it means is the indictment that ultimately was issued against Comey, Judge Fitzpatrick seems to question the propriety of that. that the manner in which it was done may have been improper and might have been a basis for the dismissal. And there's been a lot of speculation as to why Ms. Halligan did that, but it would seem to me that inexperience had to play a role in it
Right.
in some regard. Um, so you've got the only witness that testified to the grand jury was an FBI agent that had access to attorney-client privileged communications between James Comey and Daniel Richmond, and then the indictment that's ultimately issued is something different than the indictment the grand jury voted on. Um, you know,
And Richard, let me say something. I have served on grand juries for many, many years. And there are many times that we approved and said yes on something. Then they had to come back and present us the information again because they had changed the indictment. So I understand fully what you're talking about because it's a procedural protection for all of
exactly.
us that they cannot do something like this. I think it is. I mean, I don't think she didn't have the qualifications to hold that position. I don't think she knew what she was doing. And I think it created problems,
Well, and
and go
the
ahead.
shame of it's problematic, and the question is why, given that initial indictment, even though the vote was no on count one, which, as I understand it, was whether or not Comey lied about the Russia investigation, even though it was no on that count, they could have legally gone forward on that, whether it's state or federal court. If the grand jury votes yes on just one charge, you can try the person for that, you know, and see if you can get a conviction on that one charge, that one
Right,
alleged crime. So it was completely unnecessary to do that.
right.
Um, no, the other thing, touching on the appointment. No, what happened was on November 17th, in his order, Judge Fitzpatrick, questions whether or not dismissal might be appropriate. And what happens is, being a magistrate judge, Judge Fitzpatrick would have presented these issues to the district court judge to ultimately make a decision about. The magistrate judge is kind of an underlying judge
Right.
beyond the district court judge that will um, take care of important issues, but issues that largely are discovery, things of this nature, issues that the district court judge just doesn't have time for, given how busy their dockets are. So there were all of these questions about whether the Comey indictment should be dismissed. And then ultimately, another order from another judge in the Comey case led to the dismissal of the indictment. And what that judge did was that judge looked at the technicalities of Miss Halligan's appointment. And as we talked about earlier, okay,
Right.
you've got an appointment with the advice and consent of the Senate. Well, that didn't happen here. So the second thing is you've got an appointment by the Attorney General, Pam Bondi. That happened once with Eric Siebert, and Siebert resigned. So the approach that the AG's office and the Department of Justice was taking is, well, we now get to make another appointment that can run for another 120 days. And the district court judge disagreed with that and said, no, if it were to operate that way, then what would happen is the Attorney General's office could continue to make temporary appointments of the same person or a different person, and then the district court judges would never have the ability to make an appointment under the law. And because the law gave them the ability to make that appointment, what the district court judge did in the November 24th order is that judge said the 120 days is to all appointments or any appointments that could be made by the Attorney General. And once that 120-day window closes, then only the district court judges can make a temporary appointment. A permanent
Right.
appointment can still be made by the president, with the vote of the Senate, but all temporary appointments beyond that 120 days have to be made by the district court judges in that district. Now,
Right.
what effect did this have? It's kind of unusual. When Comey was indicted, the only attorney that presented the potential charges to the grand jury was Lindsey Halligan. Now, I've read in different reports that she could not get another U.S. attorney in the Eastern District to go with her to present the charges. Maybe that relates to questions about whether or not they were appropriate. It could be that she simply wanted that and wanted the publicity of obtaining the indictment. I can tell you from talking to colleagues that do this type of work that it's rare that a sitting U.S. attorney would present charges to a grand jury. The U.S. attorney for a district court in the U.S. court system is more of a manager. They're
Right.
deciding who's working on what cases and what cases we're going forward on and presenting it. You're in control of that entire U.S. attorney's office. Essentially, you're in control of and you're managing a large law firm. You don't have time to be presenting individual indictments to a grand jury. So what happens is the district court judge says that Halligan lacked the power. She was not properly appointed as a U.S. attorney. What that then means is no U.S. attorney or no one with the power to present indictments to the grand jury presented the indictment against James Comey. So what the court did was it then dismissed the indictment because Halligan's appointment was improper.
Okay, and I think there's plenty of question about it. Now, they're saying they're going to try this again or whatever else. There is a question, though, that I know that the case cannot be tried again because the time has run out on being able to file against Comey for whatever actions. So that's another thing I read.
Yes, and there are really kind of two things to touch upon there. First off, the dismissal of the charges was what was called without prejudice. And what that means is, because you never had the case being tried to a jury, because this wasn't a full-on criminal trial, double jeopardy never attached under the U.S. Constitution. And when something is dismissed without prejudice, you're free to try to do it again. You're free to try and bring the charges again. The idea is what we were dealing with here was not a substantive issue where the court examined the evidence and said the evidence was not enough for these charges to be issued by the grand jury. It was a procedural issue where things were not done proper under the technical requirements. So you dismiss the charges without prejudice to allow someone with the authority to present those charges to then come before the grand jury. So that's the first step. The dismissal was without prejudice, meaning it could be done again. Well,
Okay.
why is it that it likely cannot be done again with respect to James Comey? When someone is being charged with a crime, there is something legally called the statute of limitations. The idea is even if someone has committed the crime, there's only a limited period of time in which you can bring the charges and try them for the crime. With crimes that are deemed to be lesser crimes from the societal impact standpoint, the statute of limitations is shorter. With respect to James Comey, it is alleged that he lied or made false statements under oath to Congress. The statute of limitations for that is 5 years. That 5-year period expired in September, 2 months ago, or over 2 months ago. So now that limitations is passed, the charges should not be able to be brought against Mr. Comey again, or they could be brought, but if they're brought, all that's going to happen is another motion to dismiss will be filed based upon them being outside limitations, and then the dismissal will be with prejudice because it's taken too long to bring these charges. And again, the statute of limitations is different. I'm sure your listeners have seen TV shows where they talk about there not being a statute of limitations on murder. Again,
Right.
the more serious the crimes are, the longer the period of time you have to bring charges for them. It's kind of a benefit burden analysis with respect to the public need or public protection with respect to something like this.
And I can
So
understand
yes.
that. And I think what you've done is you have basically done everything we need on this case. And I think we do have time to go through because we're in good shape. So I think we ought to go ahead and go into the redistricting case. Because I think the one with Lulac versus the governor of the state of Texas, Greg Abbott, to me, when I read all the case law that you sent me, and I did comment to you early, I don't know how you lawyers do it because after a while it gets blurry and crazy. And I kept thinking, okay, I know this argument and I know that argument, but the two of them together are really hard to determine from what's really going on. But I think what I see in this case is whether they like it or not, and they tried to cover it up, it was gerrymandering based on race. And it was an effort to dilute minority vote. Now, I happen to know in some of the things I've read recently that they are trying to say they were trying to give Hispanics more dominant districts because they voted for Trump. But I think there's a lot of stuff going on now to cover up what they did because I think I did a very poor job. They were trying to base it on partisan politics, which I'm not a big supporter of. And you and I've talked about that with the RICO case, but I know it can be done. So there are a number of districts they're looking at: 9, 18, 22, 27, 30, 32, 33, and 35. I think most of them are in Harris County, and I think one is in Dallas, if I'm not, or two of them in Dallas. So what I'm asking you to do is first go through and see what Lulac was presenting, and who's the plaintiff, and then go and tell us what Greg Abbott and his attorneys were arguing. So tell us the case itself and then what we see as a conclusion. Okay?
Okay. So in one of our prior discussions, we talked about, you mentioned RUCO, and that being the ability to gerrymander based upon partisan politics, Republicans and Democrats. And the RUCO case involved Democratic gerrymandering in Maryland, Republican gerrymandering in North Carolina. Now, what happened is in Texas, again, you and I have discussed this, and I don't think either of us practically agree with the idea of taking a new census and drawing congressional maps in 2021 and then coming back and doing it again in 2025, regardless of the reasons for it. Nonetheless, the Texas legislature held a couple of special sessions, as your listeners in Texas are probably aware of, over the summer. A new congressional map was passed and signed into law. Lulac filed suit saying that the map was improperly using race in drawing the congressional districts in violation of I want to say it's the 15th Amendment of the U.S. Constitution. The governor's office, their defense was, no, 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 no. It had nothing to do with race. That's improper. This was entirely a decision based upon partisan politics, which is proper. No, the opinion that was issued, and not every opinion issued by a federal district court judge or even a three-judge panel is close to 200 pages, as this one is. But What the opinion that was issued found was they issued an injunction while the case is ongoing. And essentially, two of the three judges, including one who was appointed by Trump, said that in this circumstance, um, based upon the evidence, race was a factor. And the opinion is written by Judge Jeff Brown, who used to be a district court judge here in Houston, was an appellate court judge here in Houston, and was actually on the Texas Supreme Court before being appointed to the federal bench. He looked at the evidence and said that based upon the way the maps were redrawn, there were certain districts where the district was 50.1% African American, 50.2% Hispanic. And he said it's clear that these were redrawn on the basis of race, given just how close the maps are to a racial majority in particular districts. And I have to tell you, some of these maps, if you look at the opinion, the outlines of the maps are the types of things that only a map maker could come up with. There's no real semblance of order to them in any way whatsoever, be it the map in Harris County or the map up in the Dallas-Fort Worth metropolitan area. But he looked at it and said, we've got discrimination here on the basis of race. Looking at the way the particular maps came out from a racial demographic. So finding that there was discrimination on the basis of race, this is not a final opinion or a final judgment. It was what's called a temporary injunction. And the steps for getting a temporary injunction legally are, am I showing you based on this evidentiary hearing, not a full-blown trial, but a hearing in which evidence is presented? Have I shown the court that I have a likelihood of success on the merits when we finally try this case? Is there a chance of me suffering irreparable harm, meaning a harm that money cannot make up for, if we allow this to go forward in the meantime? If the answers to 1 and 2 are yes, you then move to the third element, which is, do the balance of equities tip in favor of the plaintiff, in this case, Lulac? And essentially, this is, does the benefit of putting an injunction in place outweigh the burdens of the injunction to the party that you're imposing on it? And the final step is, does the injunction serve the public interest? And through the analysis, the two-judge majority answers all 4 of these questions yes. So they grant a temporary injunction preventing the use of the 2025 map for the time being. And they say that in the interim, going forward, we'll use the 2021 map that existed prior to this new map being passed in the summer of 2025. So that's what Lulac was asking for. That's what the court did. The court said, yes, we're seeing discrimination on the basis of race, not partisan politics. And as a result, we're not going to allow you to use this map while we decide the case in full.
And what I think is important to mention is the League of Women Voters contributed to this. There's African American groups that have contributed to it. There are other Latino groups that have contributed to it. Even though Lulac is named in the case, there are lots of backup of other minority groups that are saying this is very definitely an effort to dilute, the minority vote and give us the right to have representation in Congress that we deserve. And so that's what I think is going. Now, I
Well,
read.
and on that point, I apologize for interrupting you, but on that point, when you look at the case, what they do is when these cases are issued and published, they'll list all of the attorneys and groups that are involved. And in this particular case, there are 3 pages worth of lawyers and groups that were involved in the case and participated in the case in some capacity.
Right. And I think it's saying that there is a major issue going on in Texas, and just because the Latinos voted for Trump, that doesn't mean they're in the same place now, because they are very upset about what's going in district wise. Now, I read the dissent. I think there's some real issues with it. But you say that there are two valuable points that the dissent has mentioned. So I'll leave you, because I think the listeners need to hear all of it and hear what the points are, because it's going to go more into trial. And of course, the governor is screaming, yelling, it's going to go to the Supreme Court. And he thinks that because the Supreme Court is more Republican in nature. I'll be talking about this while the lights come on. We've got to fix your office so the lights stay on all the time. Anyway, I think the point is that whatever's going on, we still have the dissent. Now, I think most of it is ridiculous, but you say that there are 2 points that we might need to know about in order to consider what happened. So why don't you give your opinion of what happened with the dissent? And then talk to us about the two legal issues that we might want to consider.
Oh, okay. And before we get to that, there are two things I want to touch on with the majority
Sure.
opinion. First off, the U.S. Supreme Court, in an order without an opinion, the order is signed by Supreme Court Justice Samuel Alito, put a hold on the injunction that the three-judge district court panel issued. So right now, as the case exists, the preliminary injunction has been placed on hold, meaning it has not taken effect due to a Supreme Court order issued by what one legal scholar has referred to as the court's shadow docket. This being orders that are issued with no opinion to explain why the injunction has been put on hold. So first off, I wanted to make it clear to your listeners that the injunction is not in place right now because the Supreme Court has gotten involved in this. And the reason the Supreme Court is involved is because when you have these important decisions like this that are tried to these three-judge panels, the net effect of that is you don't appeal to an intermediate court of appeals. What ends up happening is the appeal goes straight to the U.S. Supreme Court. So that's the first point. The second point is a lot of focus in the press and otherwise with the majority opinion has been on a letter that was sent to the state of Texas and the Attorney General of the state of Texas by the Department of Justice. And in the majority's opinion, that Department of Justice letter was the focal point of their decision-making process. And the reason for that is the Department of Justice letter said, and they printed the letter verbatim in the opinion, it directed the state of Texas that the map had to be redrawn based upon certain racial issues with the existing map that the Department of Justice was saying are incorrect or are improper under the law. And, the majority opinion pointed out that several of the witnesses who testified referred to the Department of Justice letter as ham-handed, incorrect, and the majority opinion, and this will be a good segue to the dissent, the majority opinion points out that the letter was factually incorrect and that the legal conclusions set forth in the letter were incorrect as well. But nonetheless, that letter, which basically told the state, you've got to redraw districts based upon racial issues, was the focal point of the majority opinion. That really was kind of the smoking gun for Lulac in this injunction hearing. Now, moving to the dissent, what most of your listeners have probably heard about with the dissent has nothing to do with any legal analysis undertaken by Judge Smith, who was the third judge on this panel and the dissenting judge. Judge Smith, the the dissent largely um, is very personal with respect to Judge Brown, who wrote the majority opinion. Um, he calls Judge Brown out by his full name in the dissent. And when I was a child, the only time I ever heard my mother use my full name, when she when I heard her call me Richard Gardner Wilson, I knew I was in trouble. Um, so to me, that's reminiscent of a parent calling out their child for doing something wrong. But the other thing with the dissent is it engages in a lot of political attacks. Judge Smith singles out Gavin Newsom, the current governor of the state of California, and talks about what Newsom has been doing. He singles out George Soros and argues that the lawyers that brought this case on behalf of Lulac and the experts that testified on behalf of Lulac and other plaintiffs are being paid ultimately by George Soros. I have a problem with that because even if it is factually accurate, that is not an analysis of the law. It's not the type of thing I would expect to see in a legal opinion where you're breaking down the facts and applying the law to them. Who might have paid for the expert to testify has nothing to do to me with the legal basis for the decision and the credibility or lack thereof of a particular witness. Now, where you and I probably diverge is I think that legally, when he finally gets down to analyzing the law in the dissent, I think Judge Smith is correct on two particular legal issues. And one is in these cases, as both the majority opinion and the dissent pointed out, the when you analyze the law, when you have burdens of proof, the law imposes a presumption that the legislature acted in good faith. And the law requires the district court or this three-judge court to draw any inference that cuts in the legislature's favor when confronted with evidence that could support multiple conclusions. And what Judge Smith points out is that in all of the talk leading up to the special session for redistricting, and you and I discussed it in one of our prior, analyses of all things redistricting in relation to the Ruco case, there was all this discussion about partisan politics. I remember for a week not being able to turn on the TV without hearing on the news that Texas was going to redraw the maps not to increase the number of minority districts or to decrease the number of minority districts, but specifically for the purpose of adding 4 Republican districts to
Right.
the state of Texas's congressional map. So there is evidence that supports that the legislature did this for a legally appropriate purpose, that being to draw maps under RUCO v. Common Cause that focus on partisan politics, which, as we discussed earlier on in one of our prior um, discussions, is not something that's protected by the Voting Rights Act or by the U.S. Constitution. Uh, I can be discriminated against because I'm a Republican or a Democrat. It's not protected like race. The
And one of the things I want to interrupt about here, just for a moment, is I think one of the things that bothers so much about the partisan politics is just because Trump won a large number of Latino voters. We have a 10-year cycle that we use for our census so that we can have a rational decision about what's going on in our state. So to have a odd situation occur here that only occurred after 5 years. That's where I'm really objecting to what is happening here. So I think you and I agree on that part. And your explaining of what's happened here, I don't like partisan politics as an excuse to justify redistricting. I can see how the judge had some grounds for saying what he did. It's just I don't like the fact that we're not abiding by a 10-year cycle, which gives us a much greater picture about what's going on politically. So I'll stop talking now. It's your turn.
Yeah. Well, and one of the discussions you and I have had, and it is a potentially troubling side effect of RUCO v. Common Cause. The analysis I used for you is, let's say all circles are blue and all squares are red. I'm allowed to discriminate based upon the colors blue and red, but I'm not allowed to discriminate based upon the shapes circle and square. Well, when you have a strong correlation of these two properties, where all circles are blue, all squares are red, what ends up happening is I'm discriminating based upon something that I'm permitted legally to discriminate on the basis of, but the side effect of that is that ultimately I'm discriminating on the basis of something I'm not allowed to discriminate on the basis of. And to bring that to real world facts as opposed to circles and squares and colors and shapes and things of that nature, if there is a strong correlation between the African American community and being registered as a Democrat, let's say not 100%, but a much larger percentage, then discriminating on the basis of someone's political party, the side effect of that is you can have maps that will discriminate on the basis of race. And it's something that, you know, in the majority opinion, again, Judge Brown points out that multiple of these districts, the manner in which they were redrawn, they were 50.1% African American majority or 50.2% Hispanic majority. And you know, that clearly shows some analysis or use of race is what Judge Brown is saying. But the point I'm making is, let's say that it doesn't. Let's say that that was not the basis for drawing the maps. The basis for drawing the maps was party affiliation. And I think the problem you run into there is if you're using what RUCO says is a legal basis, we're still resulting in what, in my opinion, might be an improper discrimination that is not permitted under the Voting Rights Act as it exists today while we're talking about this, or under the United States Constitution on the first issue. No, the second issue legally that I agree with Judge Smith on, and you and I discussed this, one of the other cases we discussed, and you got a big laugh about it, was the Alabama case, Allen v. Milligan. And that was the one where the Supreme Court said you improperly discriminated on the basis of race. You need to redraw these maps so that you have two districts where African Americans make up the majority of those districts based upon the population of your state. But the thing is, the court didn't draw the districts themselves. Legally, what the courts are supposed to do is you leave the drawing of the congressional districts to the legislature, because that is a power that has been granted to the states under the U.S. Constitution. The Constitution doesn't give the courts the right to draw congressional maps under Article 3. Well, what happened in Allen v. Milligan, you remember, they sent it back to Alabama and they did the same thing all over again. So the court struck it down a second time and said, okay, we've given you a second chance. Legally now, we get to draw the map. Well, again, it may be that things are different from an temporary injunction standpoint, but based upon Judge Smith's analysis, the answer to that is no. The point he's making is, look, if the map is improper, we don't impose our own map. We send things back to the legislature. And what he's pointing out, what the majority did was they said, well, the 2025 map discriminates improperly on the basis of race. You can't use it for the time being. So we're going to allow the 2021 map to be used. And what Judge Smith points out is you don't get to decide which map gets to be used in the meantime. It has to go back to the legislature because this is a power vested in the states. We need to let the state redraw the maps and try to correct its own errors. And I think legally, Judge Smith is correct on that, that the decision to use the 2021 map legally was improper by the majority. Though having said that, I will point out that this goes back to what you're harping on about them doing it kind of midway through the census in 2025. Well, in 2021, the Texas legislature drew up a map that has survived legal scrutiny and has passed muster. And that's based upon the same census that was used in 2021 as we're using in 2025. Ordinarily, with these cases, what you end up with is you end up with a map from 2010 and another map with the 2020 census. So the information is different in one way or another. There are
Right.
more or less congressional districts, the population has shifted. Here, that is not the case. So, from a practical standpoint, I understand why the majority did what it did. It's looking at a framework where none of the facts have changed since 2021. That is kind of the unique circumstance we have with drawing the maps midway through based upon the same census that was used 4 years earlier for that map. So practically, I completely understand what the majority did. It's just legally based upon controlling precedent. I'm not sure it's something it's permitted to do. Perhaps the Supreme Court will say, well, we're going to make an exception in this circumstance, given that none of the information has changed from 2021 to 2025, but I doubt it.
Well, and I think there's a problem, which you and I are going to warn everybody about, is certainly you have to pay attention to what the Supreme Court's doing about the 1965 Section 2, of the Civil Rights Act. But I
Yeah,
think
look, I apologize for interrupting, but they could issue an opinion in Calais tomorrow that wipes the entire board clean.
yeah, I know. And what that means is we would have gerrymanders maps all over the country. So I want to say
Well,
this
we
though,
already
Richard.
do, but it means they would be able to gerrymander on the basis of race, perhaps.
Yeah,
Yes.
yes. And I think that's true. And so what I want to say though is, Richard, I think we have given them the best we could possibly do about Comey, and we've given about the redistricting. And whether you and I like it or not, we're going to talk about redistricting because it's become the major discussion. I just want to thank you for the conversation we've had today. I'm very grateful to do these things with you. I'm learning a tremendous amount. And even though I find some of these longer cases confusing or whatever, I just want to thank you for all the effort that you put into our podcast. So thank you so much.
Thank you.